Your Honor, this is case number IT0367R77.4 in the matter of Vojislav Šešelj.
Mr. Šešelj, are you hearing these proceedings in a language that you understand?
Upravo pratim postupak na...
Yes, I'm following the proceedings in the Serbian language, which is the only language that I understand.
Thank you. And I give you the usual reminder that under the rules of procedure and evidence, you enjoy the right to remain silent at all times during the proceedings. Now, the purpose of today's proceedings are to enable the accused, Mr. Šešelj, to enter a plea on the amended order of indictment issued in the amended order in lieu of indictment issued on the 21st of October. At the appearance on Friday last, the 4th of November, Mr. Šešelj stated that he was not able to enter a plea. In light of the particular and current circumstances of his case, the trial chamber decided to extend the opportunity to him to enter a plea again on the amended order in lieu of indictment. This charges Mr. Šešelj with contempt under Rule 77 for failing to comply with an order of the trial chamber issued on the 15th of July 2011 to remove or cause to be removed from his website a fourth book which Mr. Šešelj has written. This book allegedly contains confidential witness information. Now, at the appearance on the 4th of November, that's Friday last, the public version of the amended order was read out, and therefore there is no need to do that again. And so I inquire of you, Mr. Šešelj, whether you are prepared to enter a plea today. I note that you have declined to answer.
Gospodine Hall.
Mr. Hall, right to legal assistance, one of the most protected rights in international law generally and in human rights law in particular. And as soon as some judge finds out that such a right is violated, he is duty-bound to intervene immediately. This right has been violated in my case. I want to use my right to legal assistance, and the registrar is not allowing me to do that. Actually, the registrar is allowing me to do it in a manner that is contrary to all principles of international customary law to exercise my right to legal aid in conditions where I would be spied on by him, and that is not the exercise of the right to legal assistance. In any other country in the world, the accused has the right to talk with his legal assistant in confidence, and that can only be considered as legal assistance if that is the way it is extended to the accused. Any violation of human rights requires the trial chamber or the acting judge to issue an effective legal remedy. That is your duty as pre-trial judge, the duty of your colleagues and members in this case. The right to defense at the earliest stage, point time when I was issued with the indictment. That is the earliest stage in the pre-trial proceedings. The right to defense exists in the investigating phase as well. It is protected in the same way. I referred to the violations in the earliest phase at the initial appearance. Even before before the initial appearance, I indicated that a violation had occurred. I said in the previous case that my right to legal aid is being violated and that I would not be in a position to submit within the deadlines the application to appeal and the appeal itself. You also know, Mr. Moore, that the trial chamber can issue any kind of order that is necessary for the preparation or the actual exercise of the proceedings, aware that these proceedings cannot be conducted without my right to legal aid being secured, that right at the beginning, without that, the whole proceedings would be null and void. So ultimately, it is your duty to issue orders that suit the situation and the circumstances, and that can only be an order issued to the registrar to ensure the exercise of my right to self-defense in the same way that this right is exercised in any other case. So you can issue such an order to the registrar, and the registrar is duty-bound to act pursuant to such an order by you. This is the inherent jurisdiction of the court to protect procedural rights. This does not even have to be articulated in the rules or in the statute. This is something that is inherent to a court. The court has to provide the circumstances for a just trial. Without a just trial, there can be no justice. You can hang me right outside this door if you wish, but that would not constitute a just procedure. So the right to legal aid being violated has violated not only my right to a just trial, but it brings into question the integrity of the entire proceedings. I must remind you, I wrote a quotation here. The Secretary General of the United Nations, in his report on the establishment of the International Criminal Tribunal for the former Yugoslavia from 1993, said, the axiom is that the International Tribunal must recognize internationally recognized standards in respect of the rights of the accused at all stages of the proceedings. I emphasize at all stages of the proceedings, since my rights have been violated because of the actions of the registrar pursuant to the European Court for Human Rights. I have suffered damage. I cannot say that this is material damage, and I cannot say that this damage is irreparable. The fact that you, Mr. as the pretrial judge, are able to correct this at any phase and restore things to their original state. As I said, the European Court for Human Rights, I have been burdened with undue suffering. I am frustrated, and I am in a really bad mental state because of the circumstances. I am confused. I don't understand the indictment against me. I have no legal aid or anything like that. And I also have a feeling of loneliness and abandonment, which is actually the definition of my situation as it can be found in the European Court for Human Rights. I have suffered moral damage, so it's not sufficient for this injustice to be corrected or an apology to be extended to me by the registrar or the trial chamber, because I am still suffering from confusion, unease, and isolation. The Inter-American Court for Human Rights and the European Court for Human Rights consider, and in their judgments they apply, that in cases such as this, violations of the procedural rights or human rights at any stage of the proceedings oblige the court to compensate me I refer to the Andreu case for the International Tribunal for Rwanda. On the 31st of January 2007, the first instance trial chamber made the decision, and on the 13th of September 2007, the second instance trial chamber made its own decision that because the extension of legal aid was late, the accused Andre Luamekuba should be compensated and damages were paid to him. In his case, this was $2,000. In my case, the damage is not as high as that. So if you were to intervene at this moment, right now, then this can be corrected in a timely manner, and then I officially will submit a claim for damages in the amount of 1,000 euros for undue concern, frustration, confusion, and the feeling of loneliness and abandonment that I have suffered. Before my right to privileged communication was taken away from me, I authorized my legal advisor, Boris Alexic, to prepare a claim for damages for these entire proceedings for the violation of my rights. Perhaps you're not aware of this, but I'm a veteran here, Mr. Hall. I have been here for 9 years already. Well, somebody switched my microphone off. I have been here for 9 years already. The first and the second year, registry prevented me for 7 months from receiving any visits, including family visits, from receiving any phone calls, except for those from the office of the warden, which I did not accept because my party gained a third of deputies' posts in the parliament, achieved good results in the elections, and there was a danger that from here I could influence the formation of the new government. There are 7 such decisions from the registry there. For a full 4 years, the registrar, without any reason, denied me my right to legal assistance and to have normal contacts with them. Ever since Maya Gojkovic, my first legal advisor, who was an attorney with international experience at that, they said she was a suspect person, so they did not authorize her to work for me. And that is what they did until my hunger strike from November and December of 2006. That is when the appeals chamber decided that all the 3 legal advisors can be registered. Then I had more difficulties from the registry. Then for a period I was left without a right to communication. When my legal advisors came, they would take me to some gas chamber where we were under the direct monitoring of cameras, public cameras, the same ones like in the courtroom here. So each word of ours, each move was recorded. This is something that is happening, that has happened several times. In 1996, no, actually in 2005, again for 2 months I was prevented from any kind of communication. I was not able to make phone calls, receive visits. I could not receive any post because the registry had suspicions that I could reveal the identity of some protected witness on the basis of one private telephone conversation of mine where I said I heard that such and such a person, who happens to be a businessman in Serbia, was doing some work for the local authority in Novi Sad, was a witness in some proceedings. Without referring to any particular proceedings, I just said officials of the local government in Novi Sad are going into all kinds of ventures with him. This is an immoral person and one should not really be cooperating with him. This is what I said. And then 2 months ban on any communication ensued. And then there was word of a proceedings for contempt of court, but this never actually took place, and then eventually I was never informed exactly about what happened with that. So these are all the reasons why, Mr. Hall, you would need to react immediately to protect my procedural rights, my elementary civil rights. This is your inherent jurisdiction, and until you do so, and until I exercise my right to legal assistance, I am not able to plead. I would like to do that gladly, but I am not able to because I do not understand the indictment.
Thank you, Mr. Šešelj. What you have said today, of course, is an expansion and continuation of what you said last week. And this matter will be taken one step at a time. And the purpose of today's hearings is to complete the matter of dealing with your plea. So having regard to your lengthy explanation, the Chamber therefore orders that a plea of not guilty be entered on your behalf. And the next stages of the hearing against you will proceed in due course. And such applications as you are minded to make, of course, you will make as advised. Is there anything else that you wish to say before we adjourn the hearing?
I do, Mr. Hall. Last time I raised the issue of the horrible food that we are receiving in the UN detention unit. It might have seemed to you to be an incredible thing, but this is today's lunch that all of us prisoners at the detention unit received. Would you be so kind to instruct the usher to take this lunch and to bring it over to you, if you agree? I don't see any reason for your concern that this is an original packing.
I don't need to see the item, but you are entitled to make the complaint which you have done. So the registrar will be informed of your complaint because, of course, the matter of the food is a matter for the regime which runs the United Nations detention unit. So, as I said, you're entitled to lodge the complaint which you have, and in the event that the authorities at the UNDU would not themselves have earlier been made aware of your complaint, having regard to what you have said in these proceedings in open court, I am requesting the registrar to bring your complaint directly to the attention of the those having custody of you at the United Nations detention unit. Is there anything else?
But Mr. Hall, it is your duty to show some interest in all the problems that I'm facing at the DU. I singled out only one of those problems. Now you are refusing to receive evidence of that. I am astonished and astounded. Why do you not want to receive it? It's not poisoned. This is evidence, and then you can pass it on either to the registrar or whoever. Mr. Gall, let us make a bargain.
You, Mr. Šešelj, you've used the word evidence. Of course, the use of that word underlines what it is when you're dealing with a court. A court can only receive evidence according to established rules of procedure. It isn't practical or useful for a party to just hand up an item and expect a court to make a determination about it. It is something which would have to be considered by the authority having jurisdiction in the particular matter, who will then make a determination, having had the opportunity and having had the benefit of hearing all sides on the matter. So if you were to hand that tray to me, it would be meaningless. There's nothing that I can do about it. Is there anything else apart from the food,
Da.
Mr. Šešelj?
Gospodine Hall,
Mr. Hall, I'm the only party to these proceedings. We do not have the OTP here. The registry cannot be a party to the proceeding. They can, however, express their opinions about certain procedures that fall within their purview. Also, you are not telling me that as a judge you are a party to the proceeding. The indictment has been drafted by the judges, so we don't have a
трибунали преузети
contradictory proceedings here that is typically taken over from the common law. Here we have an inquisitory proceedings which are typical of the European system. Here we have even indictments issued by the court itself, and it is in the hands of the court to conduct the entire proceedings from beginning to end. Now, Mr. Cole, here's the deal. Can you please take this? Just taste it a bit. And in return, I will remove 3 of my books and 5 documents listed herein from thy website. I think it will make things simple and easy. But please be so kind and receive it from me. I don't want to have brought it in vain. Just taste a little bit.
Allow you to reduce these proceedings to a farce. Do you have any other complaints apart from the matter of the food, which you would wish to bring to the court's attention?
Ja vama iznosim konkretne
I am putting before you specific facts which you consider a farce. So what's the point of any further conversation, Mr. Hall, if you believe that I brought this with the risk of having it spilled over my papers in my briefcase? You believe that to be a farce. It's not a farce. This is a concrete evidence which demonstrates the quality of the food at the DU. As soon as I pointed this, the camera moved away from it. Now it seems that registry is very anxious not to show this. I don't know why you don't want to receive this. You are not exposing to yourself to any risk. Be a human being. And please find out what kind of food the prisoners are receiving.
It appears that Mr. Šešelj has nothing else to raise. Please take the adjournment.
All right.